Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, Play the Opinion Potomac Watch Podcast. That is, Play the Opinion Potomac Watch Podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. I'm Paul Gigot with my colleagues Kim Strassel and James Taranto. James, Kim alluded to the statement by all 9 justices laying out what are the ethical standards that the justices adhere to. And they are quite elaborate. It's not as if they just go do whatever they want. They abide by the Code of Judicial Conduct that other judges do. It's a fairly extensive list. For example, just to give one illustration, the justices cannot accept fees, honoraria, for speaking, for example.
Well, they also abide by federal disclosure statutes. And a lot of these so-called ethics violations that have been uncovered by opposition researchers in the press have turned out to be either errors of disclosure or disclosures that were perfectly fine, but that the reporters didn't understand because the rules are rather complicated. But they're subject to the law. They're subject to their own ethics code. And so this is all really a ginned-up, phony attack.
You've looked into the press reports about Clarence Thomas in particular, that he has a rich friend, Harlan Crow, who has flown the justice on his private jet, has hosted the justice at his resort for several summers in upstate New York. And this, of course, is deemed to have been by the press and by the critics somehow unseemly. But there's no evidence at all, number one, that Harlan Crow has had any business in front of the court. So there's no conflict of interest there. And even on the reporting requirements, as you've suggested, there wasn't a violation, at least in the disclosure on the trips and so on.
Well, there were some things that appear to be violations according to the statute, but the directions that the justices and all other judges and federal court employees are given were unclear about what their obligations were. And remember, these are complicated bureaucratic rules that the justices are subject to. And one might say, well, a Supreme Court justice of all people should understand the law. But a Supreme Court justice's job isn't to memorize statute books. And when they are dealing with the demands of bureaucracy in their personal lives, they're in the same boat as the rest of us. They have to rely on specialists to figure it all out.
Yeah, Kim, I guess the argument is from the left that the justices should abide by the same ethical disclosures and obligations that Congress and the executive do. But of course, the judicial branch is different from the Congress and the executive, from the legislature. In this sense in particular, the judges, they can't take action on their own to say, aha, I want to pick that case. I want to go after that person. I want to go after this issue. You can do that in the legislature. You can pass legislation on just about anything. As a regulator, the executive branch can go after all kinds of issues. But as a judge, you decide cases and controversies. Yes, the Supreme Court can decide whether to hear a particular case when it is appealed to the court, but they don't get to go out there and scan the landscape and say, you know what, I really think I want to write about, antitrust this week. No, you got to have a case.
Yeah, the nature of their power and what they do is very, very different. And for those like Mr. Durbin who are calling, and I saw a statement in which he said, they should just have to abide by exactly the same, all the rules that govern what we do in the legislative and the executive branch. That's just obtuse because they're very different branches and what they do is very different. I would say that this also counts. It's notable that for the most part, and you can see this in the statement they put out, they do abide by a lot of the same disclosure rules and other rules that are applied to lower court justices. And the one thing they noted that, in 1991, they actually adopted, the Supreme Court did, the disclosure regimen that comes with the lower courts as well, too, which is requiring disclosure for things like non-governmental income and investments and gifts and reimbursements. One place where it's very different, and yet again, the left would like to claim there shouldn't be a difference, is this issue of recusals. And one thing that's very different for the Supreme Court, obviously, is they don't have a roster of people who can slide in and take a justice's position if he or she recuses themselves in a case. And that gets into very dicey territory. And as the statement from the Supreme Court justices to Durbin noted, that if you instead had some kind of standard, had a situation where the full court or any subset of the court was deciding on individual members' recusals, you could really affect the outcome of cases by deciding who could participate. And that's, of course, part of the game of the left here. They've got all kinds of ambitions with this campaign of smearing and delegitimization. But one thing they'd love to get out of it is some sort of baseline recusal standard so that they could hammer certain justices, but only certain justices, to step down with the goal of influencing the outcome of cases. So unpacking all of this takes a while, but to make the just top line case that, well, these justices should be held to the same standards as every other court in the nation and every other legislative and executive branch is just nonsense.
Yeah, Dick Durbin, as a legislature, is in a position to do favors for his friends. The justices are not, unless their friends have a case before the court, in which case they are obligated to recuse themselves. As, for example, Justice Ketanji Brown Jackson has done in a case involving Harvard this year, because she has a relationship with Harvard in which she's on some governing board. So that's perfectly proper. But Kim is right. There can't be a standard that's imposed from without on who has to recuse, because then it will be used to influence the outcome of cases.
When it comes to the disclosure rules, James, there have been revised disclosures by many justices over the years. As I understand it, Ketanji Brown Jackson made a rather extensive update to her disclosure forms when she was up for the Supreme Court. And it perfectly fine in my view that she did so, appropriate, but yet it didn't become an issue at all in her hearing for confirmation.
No, which is telling as to what the real agenda here is. And we should say it shouldn't have been an issue. It's not a big deal. It's like if you or I amend our tax returns because we realize we made an error or we find income or liabilities that we were unaware of at the time we filed. It's perfectly normal.
And I think that's a dead giveaway here about what this purpose is. In many ways, Kim, it's important for the record for us to pursue these charges and to debunk them when appropriate on the record. So there is a record of what the truth is here. But in many respects, the facts don't matter here because what they're trying to do is just create a lot of smoke, a lot of impression of impropriety, a lot of claims of somehow lack of appropriate ethics or integrity in order to create the environment where they say, aha, the Supreme Court is corrupt, this court is corrupt, or these justices are corrupt, and therefore put us in a position where we can do something about it. When they have ultimate power again of all three branches of government, can do away with the filibuster. In the Senate, it could be packing the court, but short of that, create a kind of Congress-imposed ethics board that would be able to make independent judgments about when the justices are somehow wrong. That's part of what is in the legislation that Senator Murkowski has proposed. In my view, that is a terrible idea because it would quickly be politicized.
Yeah, that's right. Compare the way that James just described all this, kind of the very technical details of this and the long history of justices making mistakes on this, with the comments recently from Senator Richard Blumenthal, who, by the way, is the guy I always turn to when I want to figure out what game is really going on, who has been out there and said that, in fact, the Judiciary Committee should be subpoenaing Clarence Thomas, not just him, but also all evidence and witnesses in these cases, because the failure to disclosure was, quote, potentially criminal, and the impeachment should be on the table. So that's an example of how they're trying to use this to gin up what you just said, Paul. And yeah, the baseline thing they're trying to get here is to delegitimize the court, and hopefully they figure at the very least maybe they can get some defensive rulings, right, where they put so much pressure on the court that the court steps back from taking some cases that the left would rather that they not hear, or rule in such a way that they're trying to protect their reputation. That's one thing. Maybe they can occasionally pressure a justice into recusing. Maybe if one day they have a really great election, they'll have teed up what they need to engage in some sort of court packing, as you noted. And now, of course, the new thing is the idea of some sort of congressional legislation. I'm not surprised that Lisa Murkowski is there. Rarely do you find a bad idea that Senator Murkowski isn't involved with. But they're going to have hearings on this now. It's not going to go anywhere because of the House. But I think it's something that people really need to be aware of, because they have completely laid out here what their agenda is for the longer term.
Yeah, this is a long game by these folks. This isn't just for this Congress, because who knows? I mean, it's very possible that they could run the table in the 2024 election, Biden win re-election. They turn the House. They only need to turn 5 seats, retake the House, hold the Senate. Manchin would be no longer the decisive vote or cinema on the filibuster, and they could then do what they want with the Supreme Court. James, where do you think this is going?
Well, one other possible long-term objective here is to discourage talented young conservative lawyers from pursuing careers in the judiciary. I remember having a conversation with Miguel Estrada in 2004, who'd had his nomination for a circuit court blocked and had been put through all sorts of hell. And I said, well, if the Republicans expand their majority in the Senate, this was just before the election, would you accept renomination? He probably would have gotten onto the court if he had. But he said, no, absolutely not. I don't want to go through that blender again.
Yeah.
And I think that the opponents of the court may have that in mind as well.
All right. Of course, we're going to follow this because this is crucial to American governance and the integrity and institutional independence of the Supreme Court. And all courts are something that we do not want to abandon, central to American democracy. Thank you all for listening. We're here every day on Potomac Watch. Catch us tomorrow for another edition of our podcast. Thanks for listening.